joining. Welcome to the TCCLA webinar, Evidentiary Objections in Tribal Court. I'm Mary Rodriguez, and I am a program attorney at NAICJA. Next slide. NAICJA is a national association devoted to supporting and strengthening tribal justice systems through education, information sharing, and advocacy. NAICJA is the training and technical assistance provider for the Tribal Civil and Criminal Legal Assistance Grant. Our goal is to provide training and technical assistance to those who participate in tribal justice systems. Next slide. Before we get started, I wanted to note that today's webinar is funded by the Bureau of Justice Administration, the BJA, and all of the points of views or opinions expressed today are solely ours and do not represent the official position or policies of the U.S. Department of Justice. Today's webinar is meant to be engaging and interactive, so we will have poll questions that will pop up on your screen for you to answer, as well as some of the questions will require you to drop your answer into the chat box. We would love to see your face and engage with you in that way. And you can raise your hand for questions during the presentation using the React button at the bottom of your Zoom application. When you do use the chat box, make sure that you select panelists and everyone so that we can all see your answers to the questions that come up. Next slide. Today, we're going to be talking about evidentiary objections in tribal court, and this is a topic I'm very excited to talk to you about. I did help develop a training module on evidentiary objections, but this is my first time presenting this topic in the webinar format. So I wanted to make it engaging and interactive, and something that you can go through whether you are not very familiar with objections or you're very familiar with objections to refresh your memory and get some practice in. Before working at NAICJA, I was a tribal public defender for over 10 years in Washington State. And so in my personal experience, a lot of my cases were resolved before trial. So I didn't have a lot of opportunity to practice my evidentiary objections until I was getting prepped for trial. So hopefully this webinar is something that you can revisit. We will be recording, so you can play it again when you're going through that trial prep time and feeling like anxious because you haven't practiced these or used these in a while. We will also be sharing resources that you can reference, and hopefully those will help you too, including cheat sheets that you can have during your trial to kind of refresh your memory about what some of these evidentiary objections are. To start us off, we have some questions to get our brains thinking about evidentiary objections on the next slide. So for these questions, you can use the QR code if you have your phone or if you're able to capture it, and you should be able to answer 2 of these questions. Johanna has also dropped the forms in the forms link into the chat, so you can access it that way as well. So the first question is, can you remember a specific objection you have made or witnessed at a trial and the outcome? And if you haven't been at trial or you haven't seen one in court, maybe you remember a specific one on a TV show or a movie or something that stuck with you. So we have a lot of yeses. I will share with you, and we can go to the next question, which is, do you remember the outcome, which was sustained, the judge agreed with your objection, allowed, the judge didn't agree with your objection, or not available, you don't remember, or you don't have an objection. So I will share with you on this one that for some reason I remember the ones I lost the most, not the ones I won, the ones that the judge ruled were allowed and I had requested an objection. And one of the things that I've learned throughout my career as an attorney is sometimes that is the best way to learn, is to get your questions wrong. So coming at that with, it's okay to get questions wrong. When we do have some of our quiz questions going on throughout this training, It's all right if you get it wrong. It's all right if you blank. It's all right if some of them were tricky questions and maybe all of them kind of could be right. That's fine. Just knowing that this is a learning process and it will help you along the way. Our next slide. Why object to evidence? This is pretty straightforward. You want to make sure that that evidence or testimony doesn't get into your case. Secondary, and this is the part that can maybe be the most stressful and cause anxiety, is if you don't object to the evidentiary issue, it's considered waived if you want to appeal it later. So one of those things is you're juggling all of these things going through your brain in a hearing is some of this stuff can be alleviated if you do some prep in advance and you identify some of these evidence or these issues or evidence that might be problematic if you identify them beforehand so you're prepared to object for them when they come to trial. Next slide, please. When to object. So this is pretty straightforward. Objecting, you always want to do it as soon as possible. As my former boss said, you can't unring a bell, so you want to make sure you're like hopping in there. Sometimes the question will be asked or the evidence will get in after you've made the objection. In that case, you can ask the judge to instruct the jury to disregard the question and the information that came out of that question. That could hopefully cure it or fix it. But of course, like you want to get in there as soon as possible so they don't even hear that part of the question. Again, you want to pay attention. You're juggling a lot of things in the air, but you want to pay attention to how the opposing counsel is entering their evidence because they have to have a proper foundation for all of their evidence. Sometimes you can assume that that proper foundation is being laid, but if you're not really paying attention, you might miss that they forgot an entire part about the information. You also can't ask your questions based on, you can't ask questions that are not in the record. So we'll get to more details on that later. But all of this is this active listening that you have to be paying attention to what's going on, to the answers. You have to be anticipating the problematic situations or evidence that can arise, and then be timely with your objections. Again, being prepared for this is usually the best way to do this. So, practicing your evidentiary objections, even when you don't have a trial in sight, is a great idea, and hopefully we can do that today. Next slide. What to do when objecting. This is pretty straightforward. State your objection, immediately state your grounds. Also being prepared to argue and explain why you're opposing this objection. Some of these evidentiary objection cheat sheets that we'll have at the end will have little lines that you can have about this is why I'm doing it. This webinar also has some slides that will also be good in explaining why some of these objections exist. Next slide. Specifically, we have some special considerations in tribal court practice. You want to make sure that you pay attention to who your jury is. Your tribal court jury pool can come from a very small community or a very close-knit community or a community where folks know each other in a way that they do not know each other in a state court or a federal court, right? I've had a jury pool where my jury was friends with my defendant, which was pretty great. But everybody knew my defendant, and we eventually whittled it down to the most, I guess I found it to be the most fair for my client, and the prosecution was trying to find the most fair for their client. But everybody knew the defendant and the person who was allegedly assaulted. So remembering that because of this, when you might be questioning somebody or thinking about like throwing in an objection, that person on the stand might be somebody's, employee or might be somebody's grandparent. And so they might look at maybe these objections as, disrespectful or kind of aggressive. And so you really have to think about, is this objection serving me? Am I being strategic with it? Is it worth what I'm trying to convey? And we'll talk about, what makes something worth it. And a lot of this is just throwing yourself out there and learning as you go. And hopefully these slides will kind of refresh your memory when that happens. Don't forget your 5 Ws. We covered some of these, but your when, how, where, about what, and why. You want to make sure that your objections, you're considering those when you're deciding whether you want to bring those objections into place. Next slide. Are your objections better served as a motion in limine? So a refresher on motions in limine, it's a pretrial motion where you can ask to exclude some of this evidence that might come up at trial, like your 504B evidence, your bad character evidence, just blank template motions that are like, I don't want this, I don't want this, I don't want this. Sometimes that can be much more effective than bringing these things up in an objection at trial. They also help you prepare in advance. Again, prep is key, but you start writing those motions and realizing like, oh, I'm going to have a problem with these issues, these evidence issues. You also get a chance to see what the other side is writing in their reply to your motion. And that kind of helps with your strategy at trial to sort of know where we are in the arguments in terms of evidence. Next slide. What rules are you using? Make sure that you know what the jurisdiction you are in and the tribal court you are in, what type of rules of evidence they have. They may have their own rules of evidence. Never assume that it's going to be the federal rules of evidence. Never assume that the evidence rules haven't changed since the last time you were in the tribal court. Make sure you are updated with the correct federal rules of evidence or the correct evidence rules of that tribal court. Today's objections will be based on the federal rules of evidence and should apply to most of your trials. But again, making sure you double check where you are, what tribal court you're in, and making sure you use their own rules of evidence. Citing their own rules of evidence also looks great in the judge's eyes. They want to know that you know the tribal court's rules of evidence. Next slide. Common evidentiary objections. Here we have some common federal evidentiary objections. This is kind of a preference. These will kind of be highlighted later on. So if you can take a quick check, some of these will come up later. There is the next slide is a hypothetical that we're going to use for our activity. So in this hypothetical, we have Mr. Adam or Mr. A is charged with malicious mischief and assault. The case alleged that Mr. A punched Mr. B, while he was carrying a vase. Mr. Bill fell down and the vase shattered. Mr. Adam quickly ran away from the scene, but the entire incident was witnessed by Miss Clara. So that's our hypothetical. Johanna, thank you for dropping it in the chat. You can refer to it for our questions. So our next slide is our first question. Our question asks, Miss Clara, on the day you saw Mr. Bill's incident, was it your wedding anniversary? Our question is, what is the best objection to this question? We have A, objection unfairly prejudicial, B, objection irrelevant, C, objection speculation. And we're going to pop this up in a poll or quiz here. If you want to answer those, I'll give you some time. And I'll give you a preference that some of these are little like bar exam questions. So sometimes there is more than one answer that could be correct or it's not listed. But for the purposes of teaching, we're going to go with the best answer is B. So good job, folks that got B. Irrelevant, as the question is asking something that has no effect of making a material issue in the case more or less likely. Next slide. So that is the Federal Rule of Evidence 401 on relevance. Relevant evidence. Like, first of all, I'll be explaining these rules of evidence from 2 points of view, the making the objection and then responding to the objection. So the relevant evidence, this is evidence that has some logical connection to a fact that matters in the case. Here, when you're making this objection, is the wedding anniversary relevant? It doesn't seem like it's not in the hypothetical we talked about. However, sometimes it can be hard to tell what's relevant and irrelevant. And so choosing when to object is really a matter of practice, is really a matter of how you, as you learn your strategies and you learn what this case is about, whether this is something that would be worth objecting to. Responding to this objection requires providing the judge a reason why this is a material issue, why this makes a material issue more or less likely to have occurred. So if you are getting at a point that that wedding anniversary is going to be relevant later, you may want to tell the judge that. You may want to sidebar and tell the judge, hey, this is going to make sense, and it's going to be relevant. However, it's probably a best practice to get to some series of questions that will lead up to why a wedding anniversary is relevant. Question two, next slide. We have Mr. Adam, isn't it true that you were in possession of pornographic material when you hit Mr. Bill? What is the best objection to this question? And in our poll, we have A, objection beyond the scope, B, objection irrelevant, C, objection prejudice outweighs any probative value. And again, this is like best objection to the question. So arguably, I think all of these probably apply. The best one, and I think the one that I just wanted to prove for the next relevant or the next evidence rule is C, objection, prejudice outweighs any probative value. Next slide. So FRE 403 is when there's this just shocking fact in there that whether or not the person answers this question, it's like pornographic material. We don't know why that's relevant, but it is an objection you can make because of it. I always think of the like shocking, like why, like anybody who hears that isn't, if they're not paying attention, they're gonna like ears pop up like, what? This came out of nowhere. Responding to this objection requires that you just need to argue and convince the judge that the relevance is not outweighed by the prejudice. Why is the pornographic material relevant? That's not clear from the question. Okay, next slide. So we have question three. Mr. Adam, when will you stop abusing your children? What is the best objection to this question? We have A, misleading, B, speculation, C, assumes facts not in evidence. So for question three, we are probably going to say the best answer is misleading, but I think it also assumes facts not in evidence. However, the reason we're going with misleading is because it is the next slide, which is FRE 403. You want to make this evidence if the evidence is relevant, but it misleads the jury in a way that isn't relevant. Um, it's I don't know why we have this objection. I don't know why that we're now talking about abusing your children. But it leads into this next practice, which would be responding to the objection by rephrasing the question in a way that isn't perceived as misleading. So imagine we know about Mr. Adam that there is a previous incident with his children. So on the next slide, we have a rephrase, our first rephrase. So our question is, Mr. Adam, when will you stop abusing your children? For some reason, we want to get out into this hypothetical that there's a previous Mr. Adam has done something with his children. So what might a proper rephrase look like? If you were going to re-ask this question in a way that wasn't misleading, but maybe you would get to the point of Mr. Adam has had like an ICW case previously, or Mr. Adam has had a dependency matter with his children. And if you don't want to share in chat, you don't have to. But again, when you're answering some of these ABCs too, if you can also think beyond that while you're answering the A, B, and C, like what's the argument I would also make, that can be helpful too. And you can write that down. So I think these are great. So we have, has abuse occurred in your home? Have you been investigated? Have you ever been accused? I have like one I had is when were your children removed from your home? The point of the rephrase is that even when you get denied these questions that you really want in, there's probably a way you can rephrase it to where you can get that evidence in. And again, this is a skill that just takes practice. Um, I will do our next question, question 4. Mr. Adam, isn't it true that you offered to plead guilty to malicious mischief if I dropped the assault charge? So here we have a question. What's the best objection to this question? We have A, objection calls for evidence of plea negotiations, B, speculation, C, hearsay. This one is not as tricky. Um, looks like folks are doing pretty good on here. There's a couple that there is some hearsay involved in this, but we'll do best answer A, calls for evidence of plea negotiations. Next slide. So that is FRE 410, evidence of plea bargain or plea negotiations. So you want to make this objection if there's specifically a question about plea bargains between you or the prosecutor, if you're the public defender and the prosecutor. Um, Usually, like this is something that you would never do. So if you are your opposing counsel is maybe inexperienced or an advocate, this may be something where you object to. But most people know you're not supposed to bring in this evidence of plea bargain. However, responding to this objection, if these statements were made without the intent to negotiate a plea, the rule doesn't apply. And that's this response one can get a little argumentative or complicated. I think maybe this one is a motion in limine that you might have that says, I would like object to all evidence that is based off of plea bargaining and put that into a motion in limine. So you can refer back to that motion in limine for somebody who might be an experienced or spokesperson. They're going to see, oh, this was already addressed in the motion in limine. So I'm on notice that I'm not going to bring that sort of thing up. That's a way to maybe minimize the situation of that showing up at trial. Next slide. Question 5. Mr. Adam, isn't it true that the doctor you saw after the incident said you sprained your knee running from the scene? This is one that might have more than one answer. All right, so for this one, we're going to say that while there is hearsay, and the reason we have some of these that say hearsay is we're going to address hearsay later because there's a lot of hearsay objections. But this one we'll talk about C, calls for privileged information. The question's asking about privileged information between a doctor and a patient. That's FRE 501. There's lots of privileged communications, making sure you know that what those are. Attorney-client, clergy, congregant, doctor, patient, spouse, your self-incrimination privilege. Responding to this, making sure that if the above relationships are present and legitimate, they're likely going to be sustained. There is some wiggle argument room if there was like a third party in the room, or if the relationship is not what is portrayed, right? Is it really a doctor-patient? Are they actually spouses? That sort of thing. There may be some room there for some argument. But most likely, you're going to know that these relationships exist, and if it's objectable, you'll object. Question 6, next slide. Ms. Clara, did you believe that Mr. Adam left the scene because he felt guilty for what he did? What's the best objection to this question? So for this question, we're going to go with A, calls for speculation. You could also object as irrelevant. There's also potentially improper lay opinion. But the most common objection is likely speculation. And that's going to be FRE 602-701. You want to make this question if the witness is being asked to speculate or to predict or to make up their ideas or hypotheticals about something happening. You would respond to this objection. So if it's sustained, you want to rephrase, remembering that your experts are allowed to testify about something that they are trained in. So a patrol officer can talk about estimated speed or search warrants. A detective is going to be able to talk about drug exchanges. A doctor is going to be able to talk about medical procedures. Um, but simply lay witness testifying about what do you think this person is thinking or was doing, that's going to be wrong under the speculation evidence rules. So our second rephrase, next slide, would be question. Would Mr. Adam have been able to render aid if he hadn't run away from the scene? So here's our rephrase. The fact we're trying to get at is Mr. Adam ran away. He wasn't at the scene. So is there a way that we can rephrase this that isn't asking Miss Clara or whatever witness who is there? Let's assume it's not, a medical professional, has nobody to lay witness. If you could drop those answers into chat as to how you would rephrase. Yeah, these are all great. Like just making sure you don't need to have the speculation part to get in what you're trying to get at, really. So, one example is where was Mr. Adam? When Mr. Bill called for help? Where was Mr. Adam when Mr. Bill called for help? That sort of thing. So you can get in the fact that you're like, Mr. Adam left the scene and he, was so, because he left the scene, Mr. Bill didn't have anyone to help him. You're able to get those in by asking a couple other questions that don't necessarily ask speculation. Next question, question 7. So we have Miss Clara. What was going on there? What's the best objection to this question? We have ambiguous, A, ambiguous, B, leading, C, improper lay opinion. There's a couple other that potentially could be in here as well. But the one that we are trying to get at would be the A answer, ambiguous. It could potentially also say calls for narrative. Um, But essentially, what we're trying to get at FRE 611A is you want tighter questions than this. Just these open-ended questions. When you're preparing your questions for direct or you're preparing your questions for cross, you want to make sure that they're clear, understandable, they're getting out one fact at a time and responding to this objection. If your opposing counsel makes this objection, you want to wait and see what the judge does, because if the judge decides it's ambiguous, then you're going to have to stop. You're going to have to think, what was I trying to accomplish here? How can I rephrase this to be a better question, a better line of questioning? And you want to ask it again in a simple way that isn't ambiguous. Our next question, question 8. Mr. Adam, you ran away from the scene of the incident because you didn't want to go to jail, didn't you? What's the best objection to this question? A, objection, misleading. B, objection, argumentative. C, objection, compound question. Great. Thank you all for answering. The best answer for this case, we're going to say be argumentative. If you the question mark, exclamation point, question mark, exclamation point was supposed to get the argumentative part in there. Um, if it's argumentative, the court probably very well isn't going to allow it. There are, some rules of evidence where argumentative could be um, There's another way to do it without arguing, right? So when you make the objection and you're really just trying to argue with the witness, it gets heated. It doesn't look professional. It's not a good idea to go down this road. You can usually solve this problem by either like an asked or answered question or a facts not in evidence question. You can, work on like impeachment, that sort of thing, but just straight arguing back and forth with a witness is just going to get you objected to, and it's not going to prove the point that you want to prove. Responding to this objection for a difficult or hostile witness, like I said, rephrase the question, use the impeachment process. If they're arguing with you, move on. There's another way we can resolve this, but just um, this can be a complicated one. And I don't know if folks have dealt with argumentative witnesses, but sometimes it really can get you off your game. And the best solution is to just move on because you want to keep your composure, you want to keep professional. They're getting flustered. This isn't their career. They're not in charge of, um, you know, being an attorney in this matter. So like try not to go down that road. Question 9. Mr. Adam, you forgot to take your medication that day, didn't you? Mr. Adam responds, no. But you've forgotten to take it, correct? What's the best objection to the second question? So we have A, objection calls for privileged information. B, objection argumentative. C, objection asked and answered. So this one's pretty easy by rule of ruling out the ones we have done already, but this could be argumentative, but here we're going to say that this is asked and answered. So this is FRE 611A as well. This objection you would make when counsel's asking the same question again, hoping for a different answer, almost like a cross-examination where they're like, you said this, and then you're like, no, well, you said this, right? This is an easy one you can use sort of for that argumentative where your objection asked and answered. Um, Responding to it, if you're the one asking the question and you asked the same question and you realized it, you can withdraw the question or you can rephrase it so it doesn't do it again. Just trying to like this isn't a good way to try and get your answers out from people, but sometimes it is, you make that mistake. But this is an easy one to try when you prep your questions for either your direct, most likely your crossed. You're going to make sure that you're getting one fact out at a time and you're not going to be asking the same questions again. Question 10. Mr. Adam, so when you ran away with Mr. Bill, you hopped on a bus to escape. What is the best objection to this question? A, objection narrative testimony. B, objection hearsay. Or C, objection assumes facts not in evidence. And for the sake of our hypothetical, let's say that the bus has not come into play yet, which would mean that our best answer is C. It's going to assume facts, not in evidence. So what this question is trying to get to is that for FRE 611A, next slide, facts, not in evidence, you want to make this question when it assumes that something which hasn't been introduced yet, like a bus trip, hasn't been introduced by another witness yet. You can respond to this in two different ways. So maybe the fact hasn't been directly testified to. It's been inferred, or like there's a chain of events that's happening. Like he got arrested and there was like a picture of him at the bus, or there was a bus ticket in his pocket. Or it hasn't been entered into evidence yet, but later it's going to be entered into evidence later. So like somebody else is going to get on the stand and say he was on a bus or I saw him get on a bus, that sort of thing. Sometimes these can get in because that where you're like, oh, this will come into play later. Part of your trial strategy is you're going to try and get these things in the order that you want, but we know that sometimes that doesn't always happen. I've had a case where my witness didn't show up the day they were supposed to, so they were a second day witness, and had to explain to the judge, like, I need this person, this will make sense. Sometimes the judge will say, nope, call your witness after the testimony that introduces it, or sometimes they'll be like, okay, this is going to be relevant later. I think if it's not, they would, object to it later if it doesn't come into play. But just understanding if you can put your questions together and your witnesses together in a way that tells the story, that lays the foundation of evidence, that's going to be easier when you do your trial prep. Question 11. Miss Clara, where were you when the incident occurred and where were you going? What's the best objection to this question? We have A, objection, compound question, B, objection, improper lay opinion, C, objection, relevance. So for this question, our best answer is going to be A, compound question. This is again under our FRE 611A. You're going to make this question when there's two answers to your question. So when you're doing your trial prep, you want to make sure that each question is asking one fact at a time. This is something that you just go over and practice. It always helps to have someone review your direct questions or your cross questions to make sure that you are really just trying to get out one fact at a time. Responding, just try not to ask them. If you do, you can rephrase or you can ask them separately. Break up your questions. So asking those two questions separately. Question 12. Mr. Adam, you will not take responsibility for your actions, will you? Question mark, exclamation point, question mark, exclamation point. Attorney moves to within a foot of the witness. What's the best objection to this question and action? So we have A, misleading, B, argumentative, C, harassing the witness. Here, our best answer is going to be C, harassing the witness. Obviously, it's argumentative as well, but the action of like the physical component could be seen as dramatic and in your face and harassment of a witness. You obviously do not want somebody to make this objection against you. Responding to it, obviously, you just don't want to do it. It doesn't work in your favor. Being clear with your body language, making sure that you are keeping your distance from where the witness is. And always, this is, your fix is rephrasing it. Your fix can be using the impeachment process if it's a hostile witness. But essentially, you don't want this objection of harassing. Go out of your way to make sure you're not harassing witnesses. Question 13. Ms. Clara, tell me what happened on the day of the incident. What's the best objection to this question? We have A, objection calls for narrative testimony, B, improper lay opinion, C, compound question. So here we're going to go with the answer of A, calls for narrative. So calls for narrative, this is one where like the strategy I think is important. If it's a question that's going to the witness is going to respond with a very long narrative storytelling answer. You can object. However, this is one where sometimes if it's like an elder on the stand, you have to be careful with your objections, right? You want to make sure that you're not interrupting somebody and appearing rude. The evidence rules do want, one question, one piece of evidence per question. However, sometimes people do start narrating. The strategies on how you interrupt this. So if it's you're doing a direct and it's your witness, practicing those strategies, talking to your witness beforehand and saying like, here's how I'm going to be asking questions. I'm going to be saying one question at a time. I want you to answer just that one question to get that fact out. I'll move on to the next question. Really like practicing with that defendant. If it is responding to it. So the direct or the witness that's on stand and they're just narrating and you want to object and be like, there's too much. You want to make sure that you're being respectful with that as well. And some of those narrations, when that witness is going on and on and on, maybe they're getting in something that you really don't want them to get in. So, this is that strategy thing of like practice of like you don't know where sometimes that narrative's going, right? Jerry, that's a really good point. If your client takes a stand and you know they're going to lie, it's best to let them give a narrative. Okay. If you are if you're not quite sure what your witness is going to say or what they're planning on doing. Maybe the narrative is the best point because your one answer questions aren't going to get the questions. You're going to get a lie question that you don't want to be asking that person. Focusing your witness into smaller bites of the story is a skill set that I have practiced, but I'm not still the best at because it is hard when somebody gets nervous to not sort of just like ramble on with these questions and not just like give as much detail or give as many answers as they can. I think that when your witness gets up there and they get nervous, they just kind of want to like tell the whole thing. So again, like practicing that and having them slow down and having them try not to be so nervous because you're going to lay the foundation for them. You're going to give them the sort of the story that they need to tell by the questions that you ask. Here we have our third rephrase. So this one, if you can drop your answer in the chat. This is like, Miss Clara, tell me what happened on the day of the incident. What's a better way to rephrase the original question? How can we turn this into either a series of narrative questions or a way that it's keeping Miss Clara focused, and maybe the fact that you want to get out is, you know, this she's gonna get, what is it, drop hit by Mr. Bill, or no, she's gonna witness Mr. Bill drop a vase and attack Mr. Adam. So maybe your questions are like, what did you hear? What were you doing when you heard the hullabaloo? I love that word. Do you recall seeing the witness? Do you recall witnessing the incident? Can you describe what you called? Um, the thing about these questions too, in your narrative questions, when you're prepping for your trial and your witnesses, there's a lot of like good, helpful things out there on just laying basic, direct questioning. Even if you don't know what the case is about, right? There's a set of who, what, where, why, when questions that you're going to be using at every trial, right? So going back and looking at those, another way to assess your 5W questions, right? When you're preparing your questions after a trial or after a hearing, when you would do these questions, really take note if like this worked really well, or like, oh, that didn't really get the answer I wanted. Maybe I need to rephrase that for the next time I'm in this situation. Question 14, next slide. So, Mr. Adam, you ran away from the incident, didn't you? Mr. Adam answers, I am a good person. What is the best objection to this witness answer? A, objection relevance. B, objection non-responsive. C, objection misleading. All right, so for this one, we are going to say B, objection non-responsive. While the other ones are, I think, arguably right as well. Non-responsive is because the witness didn't answer the question you asked. Also, FRE 611A. It isn't made to a question, this one. It's a little different. It's made to an answer. So this is when somebody is basically not answering your questions, usually done on cross. And sometimes this is like a hostile or argumentative witness. And this is a good objection, just sort of like non-responsive. And then the judge can direct them to respond, not you. So this kind of takes it out of your hand. So if a jury's looking at you and you know, kind of takes it out of your hands of being argumentative or aggressive or some way that a jury might be, you know, think negative about that situation, allowing the judge to instruct them kind of takes you out of that. I've used this before with a hostile witness. I think this was, I think I came out of it looking like I handled it in the best situation because they were getting pretty heated. They were getting pretty argumentative. They were getting really defensive over questions that I was asking them when I wasn't necessarily trying to, you know, my job was not to make them look bad, but it made them feel that way. And so I was just checking myself out of kind of the emotional aspect really kind of helps in that situation. Responding to this objection is equal to defending the witness. So you're really like, hey, Your Honor, this is why the witness is doing this. If its answer is something you want in the evidence, rephrasing that question. It's this can be a tricky one. After the objection, you want to make clear to the judge that the witness is answering, but that the like if the prosecutor's like they're not saying what they're supposed to be saying, maybe that the prosecutor wants in or the opposing counsel wants in a different answer, right? So you can make clear that the witness is answering. It's just that it's not what the prosecutor wants because they don't like that answer. Um, that's a nice little phrase to put in there. Like it is being answered. It's just not the answer that is, requested or what the opposing party would like. Question 15, next slide. It's a cross-examination question. Miss Clara, you would normally be at church at the time of the incident occurring, but you didn't go that day, did you? What is the best objection to this question? A, objection assumes facts not in evidence. B, objection misleading. C, objection beyond the scope of direct. Let's pretend that all of the questions we've had before are the scope of the direct. So our best answer is going to be C, which is beyond the scope of direct. Although you don't really have the information to know what's indirect because we weren't at this trial in this hypothetical, the point is that the questioner can't put facts in questions that haven't been testified to or that are otherwise not entered into evidence. So maybe going to church that day is relevant, but no one has talked about it yet. It's not in evidence yet. It's beyond the scope. This is FRE 611B. Again, this is like sustained only when it goes like far off the direct, right? Like if you're close, you're probably going to be okay. But if this is like out of left field, it also applies to redirect examinations. So you want to make sure that it's relevant to what was asked in the cross-examination. Responding to this is also like the last one, which is equal to defending the witness. So you want to tie the question to the previous direct or the cross exam, and you want to explain that as best as you can. Trying not to be in this situation is probably the easiest situation, right? Making sure that you've laid the foundation for everything that you want to get in question. However, sometimes when you're doing say this is your direct examination, and your client didn't say the thing you wanted them to say, right? So you're trying to squeeze it in here. So sometimes we're trying to get that in on the redirect. Sometimes you could get it in. Again, I think this is really just practice and skill on being able to argue something that was like glanced over or not really touched on. The best way is to prep a witness to make sure that they're getting in that evidence that you would like, make sure that they, you've asked those questions for them, they practice, they know that these are the facts that you would like to get in with those questions. Next slide, question 16. This is a direct examination question. Ms. Clara, you saw Mr. Adam hit Mr. Bill, correct? What's the best objection to this question? A, objection leading. B, objection calls for narrative. C, objection improper lay opinion. So because this is a direct examination question, we are getting a hint here that the best answer is A, leading. On our direct, we want our questions to be open-ended. This is FRE 611C. We always want to suggest the answer on this one. Um, this is uh, this is one where like the prep will be super helpful. When I would prep for cross-examinations, writing the facts that I would like out, and then sometimes the questions was helpful in that situation. Sometimes the court will allow some leading questions in the beginning of your direct to just sort of like prod the witness to get to the point, but mostly you are able to get your direct done without the leading questions. This is one where, if there's the beginning of a direct examination and the opposing party is offering a cross examination, you probably aren't going to be, gung ho about leading right off the bat. It's probably not going to look like the best objection for you to be making. If you're halfway into a direct examination and they're just like telling basically the person what they should be saying, that's a great time to be objecting to a leading question. Responding. So this is an easy one where you're rephrasing the non-leading question into a different question. You also don't want to suggest something untruthful. Ethically, make sure you're always keeping your answers truthfully, and those leading questions, making sure that those are ethically what you're supposed to be asking. Our next question is question 17. Ms. Clara, do you believe Mr. Adam was acting in self-defense? We have, what is the best objection to this question? A, objection speculation. B, objection improper lay foundation. C, objection ask for a conclusion of law. So for this one, we're going to do our best answer being C, objection ask for a conclusion of law. So this is FRE 701 asking for legal conclusions. Ms. Clara in this hypothetical is not an attorney. She's not a judge. She likely doesn't know the legal elements of self-defense or is an expert in that. So she's being asked to give a legal conclusion based on just being a person, right? And self-defense has a lot of components to it. So you're going to make that objection responding. So if you really want to get this in, here are some things you probably would have to argue, and you're going to have to make sure all of these are relevant and correct. So she has personal knowledge. She's familiar with the legal standards. So maybe Ms. Clara is an attorney, right? It doesn't require special expertise. You make an argument that like knowing what self-defense, the elements of self-defense doesn't require that special expertise, and that opinion is helpful to a jury. So that one's going to be a hard one. If you're trying to make these legal conclusions, it's best to make them with experts. It's not necessarily something that your witness or your lay witness is going to be able to make for you. Question 18. Mr. Bill, what did Miss Clara say to you when the incident occurred? What is the best objection to this question? A, objection hearsay. B, objection calls for narrative. C, objection speculation. So great answers, folks. We're going to do the best answer here is A, which is hearsay, because it's asking a witness to testify about something somebody else said or said and is being offered to prove the truth of the matter asserted. So this is hearsay could be its whole other webinar. It's FRE 801, 802. So hearsay, it's an out of court statement that's offered to prove the truth of the matter asserted. It's not admissible without exception, and there are quite a few exceptions. When you're responding to it, you would likely list one of these common hearsay objections, and you're probably going to have to argue why it's not offered to prove the truth of the matter asserted. So our next slide shows some of our common hearsay exceptions. We have quite a few here, and there is a couple where there's like a parentheses that has kind of what would happen. So like a present sense impression in this is like, that looks like Mr. Adam. You might be able to get those types of things in. Excited utterance when Mr. Adam or Mr. Bill, I've already forgotten. When one of them fall or gets assaulted and says he hit me, or the state of mind of the declarant who's like, my knee hurt so bad because I fell down, that sort of thing. You may be able to get those things in. Other evidence from this hypothetical that likely could get in is like if he went to the doctor afterwards to declare his injury, you're going to get the diagnosis. It could be a hearsay exception. Your diary, police report, witness statement, those are recorded recollections. Those are likely to get, those are common hearsay exceptions. Records, former testimony. If somebody's dying, you have your dying declaration, you have your statement against interest. Like, I feel terrible about hitting Mr. Bill. Mr. Adams says something like that, or I feel terrible about assaulting him. Those are things that you're likely to get in. So that's, I think hearsay objections are a skill that you would likely spend a lot of time on trying to understand the nuances of all of those exceptions and how to use them properly at trial. The best way to avoid getting objections to hearsay is having the folks who would be providing the testimony be your witnesses. No one needs to testify about what someone else said if they're there and they can testify to it. Sometimes that can be really difficult. Sometimes you're not going to be able to get all those witnesses there. So you're going to have to work on your hearsay exceptions as a trial strategy. Getting in some of those statements, getting in some of those documents, just being fully prepared that those objections are going to come into play and you're going to have to be prepared and ready for your arguments of like, nope, this is allowed under a hearsay objection. Um, a good idea to practice too, like I said, sometimes your witnesses don't show up. Um, Practice having, having your cheat sheet or whatever it is. If your witness doesn't show up, are there other witnesses that are going to need to get that evidence in and getting those ideas about your arguments for hearsay objections ready in case that happens? Hopefully your witnesses show up, but I know in some, trials I've had that they don't answer their phones or they're never were subpoenaed or whatever is happening. It's just a good idea to like practice those so they're in the back of your mind. So if a curveball is thrown, you're prepared for that. Next question, question 19. Ms. Clara, show me on this photo that the jury has not seen yet, which injury belongs to Mr. Bill? This one might be a little tricky, but A, objection calls for privileged information. B, objection, evidence has not been properly authenticated. C, objection, improper expert opinion. So our best answer here is going to be B, not authenticated. Here we have a exhibit or a photo that hasn't been entered into evidence yet. This requires a witness to lay a foundation that they know this exhibit, that they may have taken this exhibit, that they've seen this exhibit before, and that it shows what it's supposed to show. So this is Federal Rule of Evidence 901, authentication. This is another skill that trial prep and practicing questions is going to improve your ability to lay this proper foundation. So just, again, this could be another webinar of just like how to lay a proper foundation, how to ask the right questions, responding to this objection. So you want to ask your witness to lay, the questions that help them lay the foundation and help them introduce the evidence and help show that they are the person who, has knowledge of this evidence of this photo. You want to make sure that if it's tangible evidence that they're able to say like, I took this photo or I didn't take this photo, but it shows something that I witnessed. It's true and accurate depiction, that sort of thing, kind of laying that foundation. Another skill that I think the more you practice, the better you'll be at. That leads us to our slide on resources. So we do have resources that we will email out in our post-webinar email. In that has some like cheat sheets that can be helpful for you to practice. We also have some other resources I've like looked at and used. So some of those are like lawyers who have YouTube channels and kind of go into in depth of some of these evidentiary objections. One way, and like I think that this is a helpful way and puts things in a really easy, succinct manner. There's a lot of really good like bar prep and mock trial resources out there. And while like those are not necessarily for attorneys, they do put things in a very like tangible, easy way to understand that when you're just like your plate is filled with all the trial prep that you need to do and all of the like balls you are juggling to get this done. Sometimes that like very easy, like basic is just a lot easier than getting into like a legal lawyer format of these are like very advanced trial objections. If you're in a big trial where that would be really helpful, of course, using that. But I have found that these programs and these webinars for those sort of basic things can be a little more easy to digest than trying to like go down a deep dive of like evidentiary objections. That's like a 3-hour webinar before a trial. There is also, we'll be sending that out as well as we've recorded this webinar. So it's something that you can like easily use again. Another really great way to access practicing your evidentiary objections is using AI. So like going to ChatGPT and like ChatGPT making you a hypothetical and then like literally asking ChatGPT like, can you make me a script to practice evidentiary objections for the federal rules, which is like crazy that it can do it, but it can. Um, then like I think part of it, like obviously AI can get things wrong. So you have to do some like, is this the correct evidentiary objections? But I was surprised when I was prepping for this webinar that they are able to give you like hypotheticals. They're able to give you some quizzes that you can practice on your own. I always think in terms of resources, like it's very, I think the best way is like doing your objections with somebody else, practicing them with somebody else. And so like that AI can be great for putting out a script. And so even if you're just like at home with your partner or your kids, like they can read the script and you can practice the objections without them needing to be attorneys or to know if it's right or wrong. Our next slide. So I don't know if folks had any questions about evidentiary objections. I'm also available offline via email. One of the things we would really love you to do, and which helps for our grant reporting, is to access our evidentiary objections webinar evaluation. It should take 2 to 3 minutes. And we also have the evaluation in chat. So you will be at the end of our webinar, probably within the next couple of days, we will get this recording prepared so we can send out to folks. We'll be sending out our resources regarding regarding evidentiary objections, as well as some cheat sheets so that you can have those for when you're prepared. You can also share this webinar on the recording with folks in your office or your partners that may find this helpful, especially as a refresh. I want to thank you for joining this webinar and participating in this webinar and getting your brains working and thinking about evidentiary objections. If you have any questions, you can contact me, or my email is on this slide. And you can always contact NAICJA for any training and technical assistance. We're happy to help. I hope you all have a good rest of your day, and thank you for joining.